All right, I think we've got everyone in from the waiting area. I'm sure people will continue to roll in for the next few minutes, but I'm just going to do some housekeeping to start with anyway, so they can just come in and they won't miss any of the main content. So my name is Jennifer Litchfield. I am here as your host tonight, representing the Winnipeg Foundation. Welcome to Will Week. I want to begin by acknowledging that we're speaking to you tonight from Treaty 1 territory, the original lands of the Anishinaabe, the Cree, Oji-Cree, Dakota, and Dene peoples, and the traditional homeland of the Métis Nation. We also acknowledge that the water we enjoy here in Winnipeg comes from Shoal Lake, which is on the lands of the Shoal Lake 40 First Nation in Treaty 3 territory. If you are joining us from elsewhere in Manitoba, you might be on other treaty land, and we invite you to reflect on the lands and territories where you are participating tonight. We do this as part of our organization's journey to truth and reconciliation. Will Week is a project of the Winnipeg Foundation, but we partner with the Manitoba Bar Association, which is the professional association for Manitoba lawyers, and the Public Guardian and Trustee of Manitoba. So during Will Week, we offer these free sessions for legal information. They are led by lawyers who volunteer their time to do this, to cover the topics of wills, powers of attorney, and healthcare directives. Will Week has been taking place every year in April for over 15 years now, with the exception of the last 2 years, which, as you know, has been an unusual time. This year, all our sessions are being done virtually just to be extra safe, but we really hope to have some in-person sessions next April. And part of the reason that we do these sessions is obviously this information is really helpful, but also as a charity, once your family and friends are taken care of, we hope that you also consider leaving a gift in your will to charity. It doesn't have to be to the Winnipeg Foundation, to be any of the hundreds of local charities that support our communities across Manitoba. Manitobans are known as the most generous in Canada, and we're super proud of that reputation. And we know you don't have to be wealthy to do it, because people from Manitoba come from all walks of life and make donations to all sorts of charities, a wide variety of causes that are near and dear to them. And like many of our fellow charities across Manitoba, the Winnipeg Foundation has received many gifts in wills over the years. So just as you listen to the presentation today, we hope you think about how you might include the local community in your plans as well. Just a reminder, tonight is free legal information. It is not legal advice, and it won't be tailored to your specific situation. So if you do have questions about your own circumstances, you should speak directly to a lawyer. And if you need to find a lawyer, the lawyer referral line is included in the resources on our Will Week webpage at www.wpgfdn.org/willweek. And it's also included at the end of the PowerPoint presentation today. If you don't have a copy of the slides, they are also available on the Will Week website. If you need another copy, if you want to share it with your friends, they can download a free copy there. Tonight's presentation is being recorded, and it will be available also on our website later this week, maybe early next week. I shouldn't overcommit our communications team on that. Questions are welcome tonight. Because we're a larger group and we're online, we ask that you do type your questions into the chat. I will be monitoring that throughout, and I will make sure that your questions get asked to as well as I can. If you are having trouble typing your question into the chat, if you do want to just put a message in there that you'd like to ask a question, I probably can just unmute you and allow you to ask a question that way. But generally, we'd like them to go through the chat just so that we can manage the presentation. And we will pause between the different topics for questions, but feel free to ask questions throughout. Lastly, I just want to mention that there will be a link to a short questionnaire that will be sent out to you after today's presentation. So if you could take a few minutes to fill that out, we would be really appreciative. And with that, I would like to introduce the lawyer who will be leading our session tonight. With us tonight is Krista Clendenning from Tradition Law. Krista works in the areas of estates and trust, and Tradition Law is actually a firm that is focused on estate planning and estate administration. Krista's practice in particular focuses on assisting families with people who have disabilities. She is a member of the Estate Planning Council and has her TEP designation, which is meaningful to me as another lawyer. I guess that most people don't know what that is. It is an internationally recognized designation for professionals who have expertise in wills and estates. So she is your person tonight. She knows what she's talking about. And I really like to think she leads her practice not only with that expertise, but also with compassion. And that's still an important aspect of working in law. So without further ado, I'm going to turn things over to Krista, and she's going to talk to you about wills, powers of attorneys, and healthcare directives.
Great. Thank you so much, Jennifer. And yeah, so if you have any questions throughout, please stick them in the chat. Jennifer is going to do the monitoring of those questions and let us know, and stop me if I need to stop and address anything. So we'll get started here. Got a lot to cover tonight. And I just need to move my little video icon here. All right, so anytime you are doing estate planning, there are at the very least 3 documents you need to talk about, and 3 documents that will apply to everyone. And those are wills, powers of attorney, and healthcare directives. I think most people are familiar with the will. It's the fancy document that's talked about maybe more commonly. It's the one that's in all the movies when there's drama happening. So a will is a document that takes effect on death and deals with distribution of assets on death. Powers of attorney and healthcare directives are documents that you need during life, and they really come into play if you lose capacity or lose the ability to make decisions for yourself. So powers of attorney deal with financial assets, property, all of that kind of assets, and healthcare directives are going to deal with medical, personal care decisions, those kinds of decisions. So we're going to start by going over powers of attorney today. So what is a power of attorney generally? It's a document that's done by a person who's referred to as the donor, and it gives authority to another person who's referred to as the attorney to make decisions on their behalf. These decisions are related to their legal or financial affairs. And that term attorney doesn't mean lawyer in this context. It just means a person you've authorized to act in this role on your behalf. So powers of attorney are only in effect during your lifetime. So they're meant to be this authorization to allow someone to step in and take over while you're alive, but unable to manage things for yourself. There are many different forms of powers of attorney that you can have. So one of the qualities that you can choose between, I guess, for your power of attorney would be an immediate or springing quality. So this refers to when the authority of your attorney comes into effect. So a power of attorney can be immediately effective. And that means that as soon as you sign that document, the authority for your attorney to begin acting on your behalf is immediately in effect. If that attorney has a copy of the document, they can go start acting on your behalf. They don't need any later authorization. They don't need a medical opinion that you've lost capacity. They just need that document and they can begin acting for you. The other form is a springing form of power of attorney. And that form, although you've signed that document up, the authority for your attorney to act is not immediately in effect. There's a later event that has to occur. So that could be having a doctor assess you and determine that you have lost capacity to manage your own finances. And if the doctor actually signs off on the document, then the authority for your attorney comes into effect, and the attorney could take that document down to the bank and start acting on your behalf. So the clients I deal with sometimes have different opinions about whether they prefer an immediate power of attorney or a springing power of attorney. Some of it's comfort, some of it's circumstance, some of it's who's in your world and who you're appointing as attorneys. But those are the 2 kind of options available for when that authority comes into effect. Other qualities for powers of attorney include it being general or specific. So you can have a power of attorney that covers all of your assets and property, which is referred to as a general power of attorney. That's typically what we see in estate planning, because you want your attorney to step in and be able to control all of your assets and property if you lose capacity to do so for yourself. But you could also have a specific power of attorney that's for one specific purpose. For example, authorizing someone to sign off on a sale of a property when you're out of town or out of the country or something like that. So there can be a specific purpose as well. And you can have powers of attorney for overall estate planning, so ones that you do with your lawyer. Another form of power of attorney we see is with banks. So sometimes people go to the bank and you can have a power of attorney authorization added onto an account. And that's still a power of attorney, but it's actually a specific power of attorney. So it's just related to that bank account itself. If you do a power of attorney and it's all encompassing, it's a general form, you don't need to do a separate one with the bank. That general power of attorney would cover all of your assets and property. You don't need these multiple documents. And last quality for a power of attorney that's very important for estate planning purposes is that a power of attorney should be enduring for estate planning. So that means that the authority you're giving the attorney will continue and survive your loss of capacity. So that's this enduring quality. And in order to have an enduring power of attorney, there's certain requirements that have to be in place. So I'm going to hit those in a second. General requirements for powers of attorney. Oh, sorry, this one. So powers of attorney in general, you have to have capacity when you sign them. So you can't lose capacity and sign a power of attorney after that. You have to have capacity at the time you're signing the document. Any type of power of attorney also has to be in writing. So it can't be something you do verbally. It can't be done in a video. It has to be a formal written document. And in order to have this enduring quality, to have this person have authority beyond your loss of capacity, it has to be witnessed by one of these individuals here. So anytime you do a power of attorney with a lawyer, they're always going to make sure that these requirements are met. They're going to be most likely acting as the witness and making sure that your power of attorney will be enduring. So reasons that you might make a power of attorney. This allows that person to step in and manage things on your behalf. So it's kind of like an insurance policy. It's having this plan, this backup plan in place to have someone take over your affairs. Doing a power of attorney in advance allows you to choose who that person is. If you don't take that step now and you lose capacity, then you have to have someone resident in Manitoba step forward and bring a court application, which is much more work and much more expense. And you don't have control over who that person is or what powers they're authorized to have. So looking at these things in advance and thinking about what this attorney needs to be able to do will set you up in a best possible position in your case of losing capacity. Hopefully that provides you with some peace of mind going forward, and hopefully that avoids any of these more costly applications that would be involved without that document. So different things to think about when you're preparing a power of attorney or talking about a power of attorney is who you're going to name as your attorneys. One of the most important things is trust for that power of attorney. So the person that you're naming, you need to trust them 100%. They're going to be the one that's managing your assets, property, finances. If you've lost capacity and you're incapacitated for 10 years, this is the person or the people that are named to look after you financially. And we want to know that they're going to be good financial decision makers and they're not going to be skimming money from your funds, that these are trustworthy individuals. You also might want to think about compensation. So is the attorney someone that is ultimately receiving an inheritance or not? Is this something that they need to be compensated for because it might be a lot of work? It can be hard to say exactly how much work that person will be taking on because we don't know what your circumstances are when you lose capacity. You may have multiple properties that need to be sold, or things might be more simple where it's setting up some automated bank accounts or things like that. So the task can be quite a lot for some attorneys, and turning your mind to compensation and whether they should be compensated and in what amount or how to calculate compensation. And if your attorneys expect compensation or not, those are all good things to talk about with them and decide in advance. Whether your power of attorney is broad or limited, again, kind of goes to whether this is it specifically for something or is it meant to cover everything? Do you have properties that need special directions for them? So One of the rules that an attorney has is they can only use your funds and your property for your benefit. So if there's anyone else that you're providing for or supporting financially, you might want to authorize that within the document. If you're the owner of a cottage, a family cottage that your children or grandchildren use, you might want to think about authorizing those family members to continue using that property, and even, potentially noting that you want that property held so it's dealt with under your will, because this is, again, that power of attorney deals with during life and what's to be done with your property during life and during incapacity. Another thing to think about is reporting and accounting. So an attorney that's managing your funds, they are obligated in Manitoba to report to your nearest family members once a year. And that nearest family member, they could be the best or the worst for the job. So you might want to take control and designate who is that individual that you want your attorney to report to. If you have, let's say, one child acting as your attorney, do you want them reporting to all the other children, or would you rather have one particular other children involved in your finances? Some families will have individuals they don't want involved in their finances at all. They don't want them to get information about their assets. So again, turning your mind to who receives this report, who's the best person to kind of be overseeing the work that your attorney is doing, and maybe providing some direction about that in the power of attorney as well. Another consideration is homestead rights. So this is a provision you'll commonly see in powers of attorney as well. And homestead rights are these rights that evolved from back in the day when men owned all the property, and you could sell a property and take off on your spouse and children and leave your spouse and children destitute. So homestead rights were brought in so that the spouse actually has to sign off on the sale of that family property. So that family property is considered a homestead property. And even today, we have these homestead rights in place for couples, for spouses, for common law partners. So as a spouse who's commonly appointed as the first named attorney under a power of attorney, a spouse under a power of attorney will be able to sign off on everything and transfer property and sell property generally. But the one thing they can't do is sign off on homestead rights. So if as a couple, you find yourself in a position where one of you's lost capacity and you're trying to sell your family home, your homestead property, if you're acting as attorney for your spouse, you cannot sign off on their homestead rights for that sale. So you'd actually have to have an alternate attorney named in that document to step in and sign off on that one piece. So there's a special homestead provision that a lawyer would make sure is in your document to address this potential situation. If you don't have a clause that deals with this, then you're going to be forced to go to court and get a court order that deals with the homestead rights, because this wasn't authorized in advance. So some enduring POA's do's and don'ts. So first of all, we recommend that you do consult with a lawyer. There's many things that a lawyer is going to catch that need to be included or altered or tailored in your power of attorney. There is no one size fits all for any of these documents. It really comes down to, what do you own? What does your family look like? Who are you looking at supporting? What are your wishes for your documents? What are the special directions that we need for your property and any period of your incapacity? So thinking that through and consulting a lawyer, they'll be able to tailor the legal language in your power of attorney to make sure all the things that need to be authorized are authorized. And do give very, very good thought to who is going to act as your attorney. Again, we talked about how attorneys need to be trustworthy. Very important quality for anyone that you're appointing and authorizing to have access to all of your funds and all of your property. Think about who are those people that are going to receive the accounting or the report. And once you've done your power of attorney, think about who you maybe want to give a copy to, or who you want to notify to let know the people you've named, so that if you do lose capacity, they know who to look to. Sometimes you can provide a copy of your power of attorney to a financial advisor or to anyone else that you're dealing with, so they have that within their records. You may decide you want to give a copy now to your power of attorney named in the document, or alternates as well.
So we actually have a question here
Yeah.
about what you're just speaking about. Um, is it compulsory or required that you name someone to look over the accounting of the POA once a year, or is that just a suggestion to do that?
Yeah. So if you have lost capacity and you're a Manitoba resident, your attorney who's acting has a legal obligation to provide an annual report. And that annual report is to be made to the nearest family member. So it's something that has to be done, and it's something your attorney is responsible to do under our Power of Attorney Act. I think it's always a good idea to include a clause that mentions that obligation within the power of attorney, because if you don't have any mention of it, powers of attorney aren't generally going to look at the Power of Attorney Act. And if they don't end up going to get legal advice when they step in, they don't know about this obligation. So it's something they do have to do. And if you leave it silent, then the act defines who that report is made to. So generally, first it goes to a spouse or common law partner. If you have one, that's the spouse or common law partner of the incapacitated person, or to a child or a grandchild. It can go to siblings, it can go to nieces or nephews. If you run out of family members that can receive that report, then it has to go to the public guardian and trustee. So best to give that direction and also name who exactly it is that's receiving that. But ultimately, if you provide no direction, still an obligation you have, and you look to the act to see, based on the family structure, who should be receiving that report.
There's a second question about what happens if the power of attorney says specifically that the person does not have to provide an accounting.
Yeah, in my opinion, that won't work to take you outside of the legislation. So our Power of Attorney Act directs this accounting has to be made. It doesn't, it authorizes you to have control over who receives that report and name who receives that report, but it doesn't specifically authorize you to say, you don't have to make the report because I said so. In my view, personally, I think you still would be obligated to make the report, in my opinion. Okay, I'll keep going on the don'ts. So don't sign a power of attorney without getting legal advice. Also keep in mind that enduring piece. So if you're going to have a power of attorney that survives your incapacity and continues to authorize someone to act from your incapacity until your date of death, it has to be witnessed by one of those special individuals. So a lawyer is one of those people. A power of attorney isn't something you could just sign on your own at home with your neighbor, unless your neighbor is one of those specified people. Don't sign under pressure if you're unsure about the contents of that document. Again, get some advice about it, get legal advice, and go over it in detail. Ask questions about that document. If someone's putting a power of attorney in front of you and telling you to sign it, you should be talking about it and reviewing it first and understanding it first. And you should have independent counsel that you're meeting with, separate from anyone that's providing the document to you or pressuring you. So get that outside advice. Don't name anyone that you don't trust or that is not a good money manager. Again, the power you're giving these people is substantial. If they're not good with money, they are having to keep financial records. They're going to have to ultimately report to someone at that annual review or on your death. They may be reporting to your executor. So they're going to have those records. And if they don't, they're going to end up getting themselves into some trouble too. So it's not even going to help them if they're not good with money and they're going to step into this role. And don't use joint bank accounts instead of a power of attorney. And joint property comes with its whole other world of concern. Whenever you put property into joint names, whether that's bank accounts or if you put your home into joint names, you're bringing into other complications. So creditors of the joint owner, for example, if you're a parent, you think it's a good idea, instead of using your power of attorney, to put your child as a joint owner, creditors of that child could potentially go after that account. If that child goes through a separation, that account may be considered part of their assets, now open to their division of property with their spouse. There can be confusion on death about that joint account and whether it was meant to go to the child or be part of your estate divided amongst your beneficiaries. What was really the intention there? And there can be tax consequences too that muddle things if you're putting property into joint names. So Best thing to do generally is to use that power of attorney. You don't need to put an account into joint names if you have that power of attorney. The power of attorney gives that person access to the funds, and they don't need to have any joint authorization in that manner.
We have a couple of questions here.
Yeah.
One is just going back to sort of clarifying when the legal obligation of a power of attorney comes into effect. So they're saying only if the person has lost capacity, or is there another point where that would come into effect?
So the obligation to report, when does that come into effect?
It doesn't say the legal obligation to report, but maybe because it was by the same person, maybe yes, she's yes,
yeah, okay.
Yes.
Okay. So the idea behind the power of attorney is you do this document today while you have capacity. And at some point in the future, if you lose capacity, your attorney would need to be notified of that, because that's the point at which they're going to need to step in. And there may be a point even earlier than that you say, you know what, I'm having some mobility issues, or I just don't want to go to the bank anymore. Can you do this banking on my behalf? If you're in that place where you have capacity and your attorney's just helping you out, but they're still using the document, in that space, that attorney is coming back to you and reporting to you, because you're the one instructing them. They're letting you know, because you're still the overall manager of your funds. They're just doing some delegated work on your behalf. If you've lost capacity, that attorney is now obligated to step in and has to remain in place until the court removes them, or they die, or they lose capacity themselves. So they are locked in once they step in. And the reporting obligation. So once you've lost capacity to really be overseeing your own money management, that's the point at which you now have to start reporting to those other family members annually at that point. Does that answer the question?
So we actually have another question here, just looking for a quick recap. People are not quite clear on the homestead right piece of why is it that the spouse cannot sign off on a house sale?
Yeah, so if you are joint property owners, let's say you both own your house jointly as a couple, legally, as a spouse who's named as an attorney, you could sign off on the legal sale. Like, you can sign off as the owner because you're authorized under the power of attorney to do that. Our homestead legislation, though, it's the separate piece. So the whole reason homestead rights were brought in was so that a spouse couldn't sell a property from underneath that partner. So it's just this one exception where, as a spouse, even though you're authorized to do everything under a power of attorney, our legislation doesn't allow the spouse to sign off on the homestead rights. It has to go to another person, because someone else has to be involved to make that decision. Otherwise, you've just given the spouse all the power anyways. Does that make sense? It's a hard thing to explain. Or I guess we'll find out if we have follow-up questions on it.
Yeah, it's a little bit clearer, they're saying.
Okay, all right. I'll move into healthcare directives now. All right, healthcare directives. So this is kind of like the flip side of a power of attorney, in that the power of attorney was dealing with your assets and property decision-making. The healthcare directive deals with medical decision-making. A healthcare directive is what we call it here in Manitoba. It goes by other names in other provinces and other jurisdictions. Living wills is another term we hear here. You might hear power of attorney for personal care. That's a term that can come out of Ontario and other places. So all these things are kind of the same concept. The idea is you're appointing someone to make medical or personal care decisions for you. That person is generally referred to as a proxy or a personal decision maker. Healthcare directives basically do two things. They can name, firstly, persons to make decisions on your behalf. So in the same way that a power of attorney names attorneys to make financial decisions, the healthcare directive will name proxies to make medical decisions. You can name certain like alternates, first, secondary, third, in an order, or joint people to make these kinds of decisions for you. So appointing these decision makers is the first piece of a healthcare directive. The second piece is providing specific wishes about what you want in certain circumstances. So one of the classic things is I want to pull the plug if I'm not going to be regaining a meaningful manner of life. So you can provide any kind of direction you want regarding your medical care in a healthcare directive as well. Typically, it's dealing with end of life directions. But those are the two main functions. You can have a healthcare directive that does one or both of those things. Entirely up to you. To have a healthcare directive that is valid in Manitoba, it has to be in writing. It has to be signed and dated by you, so signed by you. The maker of the healthcare directive has to be over the age of 16. They must also be mentally capable of giving informed consent. So this is this kind of, again, concept that they have capacity at the time of doing the document. The healthcare directive must also be brought to the attention of healthcare providers. So if something happens to you, that person that you've named as a proxy has to be able to present that document to show that they are your chosen decision maker. Another important thing to think about with your healthcare directive is where you store it so that it is something that can be found. One of the things that people tend to do is put their healthcare directive on their fridge. There's also something called an ERIC kit, so emergency response information kits. These are kits that you can get at various senior centers, and they include emergency information, can also include a healthcare directive, and they're stored on your fridge, and emergency personnel know to go look there if they have to attend your home for anything. So that's a good location for storing. Always a good idea to give your healthcare proxies copies of the documents so they have them as well. You can also consider keeping a copy in your purse or your car or in your wallet in a smaller form, or a folded up form, I guess, is also an option.
Do you have one? Oh, sorry.
Yeah, go ahead.
Didn't mean to cut you off. We do have one question here. Do you suggest that people provide specific directions in a healthcare directive, or can you just state who your decision maker is and that they can make whatever decisions that person wants?
Yeah, so it's so hard to contemplate exactly what situation you might find yourself in, of course. It's hard to know, given all the circumstances, what directions to even provide. So it's really up to you. If you have strong wishes about something in a certain situation, or strong wishes about what you want in terms of end of life care directions, then certainly include those directions. You don't need to do that if you are in complete faith of the people that you're naming as proxies, and you know that they understand where you would be coming from and what types of decisions you would want made, and that you trust their decision making in that manner. Then you can just leave the decisions to them. So it's really depends on you and the extent of maybe the control that you want over the decision making, or even the individuals that you're appointing. Is there certain decisions you maybe want to take out of their control? For example, like saying, if I'm a person who is being kept alive by machinery, I don't want you to be resuscitating. I don't want you to be continue to, keep me alive by those machines. Like there might be different things that you don't want to put that difficult decision on your family members, and you'd rather write it out so that it's kind of taken out of their control. So hopefully that kind of gives a little bit more guidance. In terms of when a healthcare directive comes into effect, I suppose when you sign the document itself, it is in effect. We don't have this like springing situation like we talked about with powers of attorney. But when it's going to be used is when you're no longer able to communicate your own healthcare wishes or healthcare directions. So only once you have lost capacity to provide those directions, or you're unable to communicate those directions, in that case, the proxy will step in and provide directions on your behalf. An important thing to remember with capacity is that it's task specific, is what we say, which means that it depends on what the nature of the decision is and whether you have capacity to make that decision or not. So you could be a person that's losing capacity and you may not understand the complexities of choosing to take a certain medication or not, or change medications. That might be something your proxy is deciding for you at that stage, but you may be able to decide, what you're having for lunch, or what room you're living at the residence or something. There's certain things, if you can understand the consequences of that decision, then it's a decision you should make. And we should all be supporting, healthcare facilities should be supporting people in making decisions to the extent they're competent to make those decisions. So healthcare directive only comes into play when the person can't make those decisions for themselves. And the healthcare directive will remain in effect throughout that period of incapacity. If you regain capacity, regain the ability to communicate your wishes, then at that point you regain control over your own decisions. So it's only while you don't have capacity this person stepped in, and this authority also will go from the period of incapacity until the date of your death.
There's a question here about, can your healthcare directive include organ donation, or is it only for decisions before your death?
I've seen organ donation in healthcare directives before. I think it's helpful to have everyone be aware that that would be a wish that you have. Best thing, I think organ donation, the best thing you could probably do is make sure you're registered for Sign Up for Life. So I think Manitoba has consolidated everything, so it's all online now. There's a website for Sign Up for Life. I want to say signupforlife.ca. So if you Google it, you'll definitely find it pretty easy. And registering there as a donor is your best thing to do. But certainly, if you want to include that in a healthcare directive, you can. Ultimately, they are going to look to family members to confirm those wishes as well. But if you've signed up and acknowledged your wishes, then that's going to override things.
I just wanted to mention, you had mentioned the ERIC kits earlier, and so we posted a link in the chat where you can find a bit more information about that, and it actually does also conveniently include the link to Sign Up for Life. So,
oh, perfect.
Got both links in one.
All right, so considerations when naming a proxy. So a proxy would have to be over the age of 18 if they're making decisions on your behalf, and they themselves also have to be mentally competent. The proxy should be consenting to act. So for any of these individuals, whether we're talking about attorneys or healthcare proxies, or we'll talk about executors soon, it's best to talk to those individuals and not have it be a surprise to them that they're appointed, and make sure that they're willing to take on these roles, because these roles can be very significant, very time consuming, or very serious. So good to have those conversations in advance, and to let in the healthcare, in dealing with the healthcare directive, letting the proxies know your wishes, to kind of have conversations about what you'd want in different circumstances. So they do kind of have some guidance if they have to step into one of these roles and are faced with a situation that was unexpected and they're having to make a decision on your behalf. So how do the proxies make healthcare decisions? So first of all, they are going to be guided by the directions you've provided in the healthcare directive. So if you set out those specific wishes, they're going to look to those wishes first. If you have not provided any specific wishes, then the decisions are to be in accordance with wishes you've expressed to them while you were competent, and that you would still be expected to act upon, and other recent decisions that you have made while you were competent. If there's nothing to go off of in terms of those wishes, then that healthcare proxy is to be making decisions in your best interests. So whatever is the best thing for you in their opinion, and that's what they're to be guided by.
There's a question here about your proxy. Does the proxy need to be a Canadian citizen? And a sort of a two-parter, do they have to be in Manitoba? What would happen if you're not local?
Yeah, so there is no requirement that a healthcare proxy is in Manitoba. You don't have, because they're not connected with property. You don't have the tax difficulties you have if they're an executor. You don't have like an out of country executor as an example. But I mean, I guess there's practical difficulties. It's someone they can contact, right? So on your healthcare directive, usually you're going to have the phone number, the contact information for that individual. So are they in a time zone where they're going to pick up the phone? I've had clients who want to appoint people who like live out on yachts and they're like out of service for periods of time, and like, well, maybe not the best idea. So it depends on the individual. And if that's the best person to make healthcare decisions for you and they're out of the province, then that's totally fine. Or even out of the country would be fine too.
Definitely seen over the last couple of years, medical professionals like trying to make it work to reach people where they are as much as they can, because they want to consult who you name. So yeah, I think they try to the extent they can to reach people.
Yeah, so I mean, it's good that they're trying, but I mean, there's probably no replacement for someone that can come down to the hospital or come down and deal with the thing if they need to. So our dues, we're on dues for healthcare directives. So talk about your wishes with your family, with the proxies. Again, no surprises, really helpful in terms of people making decisions later when you're gone, or accepting decisions later. If you're just open with what you've included in your healthcare directive, or even like who you've named, if you're naming one of multiple children and you think they're going to be offended, like even explaining to them in advance why you're making that decision. If you do have 2 kids that are out of province and one is here, maybe that's your reason and you just want to explain that to them so they're not offended when something happens. Do give copies to your proxies, to your physician, family members. Good for everyone to have a copy that might need it, or that way everyone has a copy if someone does have to rush down to the hospital with the document. And if you're including specific directions about treatment, I mean, even, I'm a lawyer, specializes in this stuff, but I don't know the best medical directions to provide or how to properly word specific things. So it's really good to talk to your own doctor about what you want and how to word that, so that when a doctor is reading it, or the medical professionals are reading it, they know how to interpret it and they understand it, because there can definitely be a disconnect between us lawyers trying to write something and the doctors and the instructions that they're trying to take or glean from that. So and that goes to the next one, do use clear and concise language when expressing your wishes. It doesn't have to be, it maybe shouldn't be legalese, that kind of worded document. Okay. Now our don'ts. Don't put the only copy of your healthcare directive in your safety deposit box or anywhere that it can't be found. Again, we want to make sure it's an accessible document that people have. If this document isn't found, it's not helpful to you, because then no one knows who's supposed to be making these decisions, or that anyone was ever appointed at all. So don't keep it a secret. Don't use the jargon in there. And the last thing I will say on healthcare directives. So one of the options we have in Manitoba is Manitoba Health, and the WRHA has put together a form of healthcare directive. It's a very simple 1-pager, and it does the job of allowing you to appoint a primary healthcare proxy and an alternate as well, or you can appoint 2 people jointly the way the form is set up. There's also a little box for specific directions that you can write in, and then it gives you the space for dating and signing that document. Typically, when you're filling it out, you want to make sure you've got all the proper contact information for those individuals, so it's all done at once. That form is a good form. So if you can access that one through WRHA and maybe Manitoba Health, I think now too. Jennifer knows.
I can post it. I just posted a link to it directly to the form.
Perfect. So the nice thing about the healthcare directives is this is actually one thing you guys could do today if you wanted. Healthcare directives do not need a witness, and they do not need a lawyer to make them valid in any way. You can actually fill out that document yourself and sign it, and it will be a valid healthcare directive for here in Manitoba. So I encourage you to take a look at that and see if it meets with your needs. You may want something more detailed, and you can always get a lawyer to assist you with that too. Okay. Moving on to wills. All right, so I keep having to shift my little screen here. What is a will? So a will is a document that is going to distribute your estate on death, and it takes effect at the time of passing away. Your estate is going to be anything that you own personally at the time of death. So your estate will not include something that's owned jointly. So you have joint property with the spouse or someone else. There's a right of survivorship, so that property stays with the joint owner. If you have accounts, investment accounts, or life insurance that has a beneficiary designation on it, those funds will pay out to whoever's named as beneficiary, and those funds do not become part of your estate in that case. So all the other things, property that's owned personally, accounts that are owned personally, your vehicles, your other possessions, everything else falls into your estate. And that is what your will deals with. So the will distributes the estate and provides directions about who are the beneficiaries of that estate. And a will, even if a will distributes certain assets to certain people, that doesn't stop you from distributing assets during your life. So you might sign a will this year that gives your house to your child on death and your cottage to a sibling and everything else to the rest of your kids divided up equally. If you then in 5 years sell your cottage to a family member, a different family member, and you exchange your house for a different house, those gifts of those properties would no longer take effect under that will because that property is gone and you've replaced it. So it's important to think about what your directions are under your will and what your property is, and that the plan all matches up as well. And other things to think about too would be how you're distributing property between kids, and if you're trying to equalize things with different assets, there can be unintended consequences with things like that as well. I know I've seen cases where someone might think, a parent might think they'll give the registered investments like a RIF and RSP to one child and then leave everything else to the other child because the values are very similar. But you can forget about things like tax consequences. So an RSP would have a tax liability that's still within it, and that tax liability will hit your estate, whereas the beneficiary gets those funds completely out of the estate, so they don't get the deduction for the taxes. So you could end up with an unequal distribution, even though you're thinking you were leaving equal assets between kids. So working through the plan and what it actually looks like on death, after death, taking into account taxes, taking into account the plans for what might happen with your property, all very important things when you're looking at will planning. Formal requirements for your will. So again, document has to be in writing. We don't have any ability to probate video wills yet in our world. Document has to be in writing, and the maker of the will has to be over the age of 18. The will also has to be signed and dated by, we call it the testator, so the person who's signing the will maker, and it has to be signed in the presence of 2 witnesses. And at the time of signing, you have to have capacity. So you have to understand the nature and effect of the document you're signing, really understand what that distribution is, what it means, who you're leaving out, if anyone, who else maybe might have claims against your estate. You have to understand your property, you have to understand your family tree and makeup. So all those things have to be in place when you are signing a will. And those are things that the lawyers actually assessing as they go through a will making process with you and making sure that you have the necessary capacity to do this document and making sure that your wishes are going to be followed. Another document that you would need actually alongside your will is called an affidavit of execution. So if any of you have done a will before with a lawyer, you'd probably be familiar with this document, or you'd see this page at the end of your will and maybe wonder what it is. And every time a lawyer does a will, we will do an affidavit of execution. And it's a document that we're swearing, saying that you had capacity when you signed the document, that there were those 2 witnesses there, that those 2 witnesses were people that weren't beneficiaries under the will. Like there's certain people that can't witness a will. So that document is something that actually has to be stored alongside the original will, because both the will and the affidavit have to be admitted to court on your death for probate. So that's a piece that sometimes is missing if people do their own wills. And again, just requirements. So it has to be signed and dated. 2 witnesses have to be present when the will is signed. Witnesses have to be competent as well. And the witnesses cannot be beneficiaries of the estate or a spouse or common law partner. So you really want to have someone removed from the will itself, Generally, if a lawyer is signing that document with you, it's typically the lawyer acting as a witness with a paralegal or another staff person that's removed from your world. Now, big question, what happens if you don't have a will? So if you pass away without a will in place, then we have an act called the Intestate Succession Act. So when you die without a will, you're said to die intestate. And this act sets out how your estate will be distributed. And it basically depends on what your family structure is. One of the concerns that people often have is, if I don't have a will, is all my property just going to go to the government? Are they going to take everything? And that won't happen. You'd have to have just like no family whatsoever. You have to go pretty far up the family tree to look for descendants before anything's going to go to the government. But so looking to this act depends on your family structure. If you, for example, pass away with a spouse and you have children with that spouse, everything would go to that spouse generally. If you pass away and you're in a blended family situation, so you may have a new spouse and kids from a previous relationship, you're going to end up with a split that, let's say, is generally 75% to the spouse and 25% divided amongst your children. So those are just examples, very, very basic level. The way that it plays out just absolutely depends on what your family tree looks like at the time of death. But the idea is it's a one size fits all distribution. And if you want anything other than that, then you want to make sure that you're doing a will. The other thing that the Intestate Succession Act will not allow for is charitable bequests. So any gifts to charity, those will not be authorized. Your family would not be able to make them from the estate. They have to distribute the estate in accordance with what this act says.
There is a question here, I think going back to the previous slide about witnesses, and it's, can you have a will like in the movies where there's just witnesses but no lawyer saying the person is of sound mind? I think I'm reading into that a little bit of like, what does it mean if you don't have that affidavit of execution?
Yeah, so if you've done that, will and you don't have the affidavit, so I do see this, and not only do I do will planning, I actually do estate administration. So I work with executors in these situations too. And what we typically have to do is go track down one of those two witnesses. So there's presumably two witnesses. We try to figure out what those names are and track those individuals down. And we need one of them to then sign an affidavit that sets out that information. So it's something that the court needs you to provide. And if you can't provide it, you've got to explain to the court why you couldn't and all the steps you went through to try to locate those two witnesses. And you have to go pretty far. I had one last year where the paralegal we had to track down had moved like to the UK, and we had to make sure we had to send the actual will all the way to the UK and get her to sign off on it and send it back. So the court's going to make you go through those hoops, and that is not a cheap process. So getting that affidavit done at the time, way, way easier than trying to track down these witnesses later, because if you did that will years and years and years ago, your witnesses might have died, your witnesses might have lost capacity. You better hope we can read the signature of who's even acted as a witness or that their name's on it, because sometimes you just have a messy signature. So it's definitely, it creates more work on the administration side. Okay, so intestate succession, we talked about that. Reasons for making a will. So just making sure that your wishes for your estate are followed through on, setting out those specific wishes in your will. One example might be, so we're going to get into like a disability aspect of this, but commonly with disability planning, I see family members, like parents might have a house that they've tailored for a child with a disability. And the plan may be for that child to continue to reside in that home. And if that's the case, then we've got to have tailored wishes for that house to go to that child or be taken as part of their share. We might need some provisions about how we're dealing with expenses for that property, setting aside money. So dealing with something unique like that, you would have to have wishes set out in the will. Costs related to not having a will. So in the case you don't have the will, and it's that Intestate Succession Act that applies. You also don't have an executor because you didn't do a will. So the will appoints an executor. If you don't have that, you have to have someone apply to court to be named an administrator. And an administrator is essentially the same role idea as an executor, but they are court appointed. And we have to have Manitoba resident administrators. So you cannot apply to court if you are not resident in Manitoba, if you're a person that died in Manitoba. So that can also limit families if they don't have Manitoba resident family that can step in and act. You can name an executor that's outside of Manitoba without any issues. You could have a family member in BC or Ontario, wherever, if they're still in Canada, non-issue as long as they're named as an executor. But these administrators have to be Manitoba resident. So there's a cost to doing that application. So it's which process you end up following. Whether you have a will or not, you're going to have to bring generally a court application. If you don't have a will, you absolutely 100% have to bring a court application to gain control of any of the assets. When you have a will, it just depends on what assets you die with. You may or may not need to go through a court process. We'll talk about that later. Distribution of property. So just again, giving specific details about how the estate will be distributed, and you may have specific wishes about things. You might have personal effects that you want divided in a certain way, or family heirlooms. If there's debts owing by a beneficiary to you that you want to forgive, you may want to deal with that in the will. Or if there's adjustments between shares of children because maybe one owes you more, or you want to provide more to one or the other, all that needs to be provided in the will as well. There's also certain tax planning you can do, making sure that you're able to use different rollovers that are available to register investments or property. Accessing those, doing some planning around those issues can make sure that your property is exchanged in the most efficient manner, reducing any taxes and fees that you might otherwise have to pay if you're not really turning your mind to those things. Trusts are another big one, and we'll talk about a Henson trust, which is a specific type of trust that we often use when we have a beneficiary with a disability. You may also have a trust for a young beneficiary. So if there's any chance you might have someone inheriting under your will that would be under the age of 18, or you could even set an older age, 21, 25, and you want funds to be held for them until they reach a more responsible age, you can have a young beneficiary trust, which provides certain terms about how that money is accessed and paid out to a young person. So that's another use for trusts in a will. Guardianship might be another thing. So if you have children that are under the age of 18, you may want to provide specific directions about who would step in as a guardian if both of the parents have passed or all the parents have passed away. Wishes for guardians can be a bit of a surprise to people, that you don't have absolute control over who is named as a guardian under the will. So you can provide whatever wishes you like in your will. Ultimately, our court is responsible for appointing a legal guardian. So an application still needs to be brought forward by the people you're appointing or some other person, and the court ultimately just decides what's in the best interests of the children of who should be that legal guardian. So providing those wishes, though, in the will are generally going to be persuasive about to the court in terms of who should be stepping into that role. Oh, didn't mean to switch yet. Blended families is another big planning area with wills and estate planning in general. So a common issue that comes up with blended families. So blended families are generally like a situation where you have spouses which have kids from previous relationships and they've come together. So those spouses may want to leave everything to the surviving spouse so that they're taken care of for the rest of their life. But when both spouses are gone, they want both sides of the family, both sets of children, then provided for at the end. So with a will, you can always update a will. So if one spouse passes away, the surviving spouse could update their will and cut out this side of the family. There's nothing that can be done about that. The person's free to change their will. There's nothing binding on that couple to keep their wills the same. There's certain strategies that can be brought in for blended family planning in that situation. We do something called an estate plan agreement, which is basically a contract between the spouses, which binds them to leave their estate in an agreed way. So it actually makes their wills binding. And if they are changed or something, property is given away, it gives the kids something to rely on and an enforceable way to get their inheritance when both spouses are gone. So lots of considerations when blended families are in play, just because of these different pieces that come into effect. And you can't just, leave everything to your own kids, because then your spouses have claims against each other too, as dependents or under our Family Property Act. So lots to think about there. Definitely one where you need some legal advice if you're in a blended family situation. And just in general, having that will in place makes things a lot easier on the family. You're not trying to figure out who can act and what the rules are. You have a designated person who's able to begin doing things right away when they're appointed as an executor. So there are certain things that they can do without having probate or going through any court process. They may not even have to go through a court process if your assets are quite simple on death. So if you've got small bank accounts, no real estate, you may be able to use that will to administer the estate fully and distribute funds to beneficiaries without ever having to go through any court process. That would not be possible if you didn't have a will.
We have a few questions here. Quickly, just a clarification that for children under 18, the court has final say on the final caregiver if both parents are gone.
Correct.
And then a question about executors. So can I name someone living in the US as an executor of my estate? For example, a child that's living in the US.
Short answer, no, we should generally never do that. So the reason for that is executor who's appointed, who's resident in the US, will cause your estate to be resident in the US for tax purposes. So you're now filing Canadian tax returns for you as your Canadian person, and you've now created all these IRS filing obligations because you have a US resident executor. And from the clients that I've seen go through this mess, you don't want to do it. I do not recommend it.
We have another question here related to guardianship, actually a couple. So what happens if you die intestate, that means without a will? How does guardianship get handled in that case?
Yeah, so in that case, you would need someone to apply to court to be named as a legal guardian. So you're going to have a family member, someone who's able to take on those kids or that child, bring that application and get court appointed. So that process is going to be needed.
And the second question about guardianship, is it more complicated if your appointed guardian is non-Canadian? I don't know that they would appoint a non-Canadian guardian. Maybe.
Yeah, so you're moving the kids out of the country.
I think the short answer would be it's more complicated.
Yeah, it's going to be complicated. Like, I imagine you're going to have to go through those proceedings in Manitoba if that's where the family was, and then you're going to have to put forward, I imagine, a good plan about what's happening there. I haven't dealt with a guardian. That's probably almost more of a family lawyer question. That one, I haven't dealt with it.
Those are all the questions for now.
Okay, we're good. Okay, I'll move forward. Okay, so is a lawyer needed to prepare a will? So technically, no, you should definitely get the legal advice, because the complications that come in with wills and the messes that they can create are many, but technically you can do your own will. So there are will kits that are out there that you can purchase and fill in the blank, which again, do not recommend. And there's also something called a holograph will. And a holograph will is when you actually write your own will. So start to finish, all in your own handwriting, and you sign it and date it. And you don't actually necessarily have to have any witnesses on that document, but if it's all within your own handwriting, it can be admitted to court as a will. The issue with holograph wills, though, are many, but where to start? So, you don't have a lot of the necessary pieces that you might need within that document. So powers or authorizations that the executor might need, the language that's being used can be incorrect or hard to interpret, or it's not the proper legal language, which means what you're trying to say. So lots and lots of interpretation issues, which generally would lead to additional court direction or applications, or even potentially like litigation or fighting among family if they're fighting about the interpretation of something. I actually have an interesting one right now was a will that has numerous holograph amendments made to it. So we're working through this one right now, and some of the content was like completely unrelated to property. It's, how long her spirit was remaining in a property, or like different things. So it's the things that get written down and then admitted to court, but like aren't relevant necessarily. It's hard to work around and interpret and deal with, but it's the issues that you're leaving those executors or administrators with. So definitely interesting when we see holograph wills, and again, recommend instead getting something written up properly by a lawyer.
We do have a few more follow-up questions around guardianship. So there's a couple of comments around what happens when you are an immigrant family and you don't have family here. So I think that tied into that question around it being more complicated. I think you mentioned this, that the application would be in Manitoba where the children are. So the question, if the child had citizenship in another country, would it be easier to have a guardian put in place outside of Canada? And I think implied in this other one is, what happens if you don't have family here that can step forward and make that application?
So this is all related to guardianship, those questions? Yeah, okay. So if you've got family outside the country, the kids are citizens of another country, it's kind of more of a family. I haven't had to deal with guardianship applications in this way. I imagine if there's like, it'd be easier for you to move the kids back to the country they were from. If they're already citizens there, it's probably going to be an easier process to have guardians appointed in the other country. You may be, I don't know if you could bring that application in the other country. You're dealing with like some international law and stuff that's a little bit outside of my day-to-day. I'm sorry, I can't give you a good answer on that one.
Yeah, and honestly, I don't think we've actually ever had that question before on this topic. So that's interesting, and maybe something that we could incorporate into a future presentation.
For sure. We'll bring a family lawyer into the next one that's
to partner with
guardianships. Very thankfully, the estates I deal with, I don't see many kids that parents have passed away, thankfully. So I haven't had this issue come up yet in my practice, which I'm thankful for. So
we hope that no one has to deal with this situation immediately.
Yeah. But again, it is planning for the worst, which is absolutely what we're doing here, is planning for the worst. So it's a good question to ask now and work through now and figure out what would happen so that we can plan for it. So thank you for bringing us that excellent question. Okay, I will move on to our next one here. What are will kits? So will kits are fill in the blank wills. I think there's all different kind of types. I think there's things you can get online these days, stuff you can order in the mail and buy in stores and things. Another good cautionary thing is with will kits, they may not even be designed for the same jurisdiction you're in. So we're dealing with Manitoba, and Manitoba has specific forms, and like that affidavit we talked about, that's a specific court form. And those things vary from province to province and certainly country to country. So if you're even pulling something out of Ontario, which there are certainly a lot of materials that are Ontario based, just given the size of the population in that province, you're likely not dealing with the right thing. And if you're pulling like powers of attorney, their powers of attorney look different. They don't have healthcare directives. They have powers of attorney for personal care. So there's just differences from jurisdiction to jurisdiction, and the technicalities of dealing with Manitoba documents and the technicalities of dealing with the exact types of assets you have and the family structure you have and the wishes you have. You've just really got to closely consider that. And there is no one size fits all. I mean, every will that I'm doing is tailored and is different. It's, they're always different depending on what all those different factors, when you mix them all together, what comes out, and everyone needs a slightly different document, which makes it hard for you guys because it's not an easy thing that you can just go do on your own. So who should consult a lawyer? That brings us to this part. If you have, so the larger, more complicated the estate, certainly the more need for a comprehensive estate plan with advice from different professionals. If you've got a large, complicated estate plan or estate, complicated assets, you should be working with not only a lawyer, probably your accountant too, probably your financial advisor, bringing everyone in to get their consultation on what the best estate plan for you is. If you're someone who has been married, so marriage in Manitoba revokes a will. So if you had a will on Monday signed up or from the past and you get married on Friday, your will is now revoked and you're going to die intestate because you didn't have a will. So marriage in Manitoba revokes a will. Kind of a shocking thing sometimes people don't know about. Separation or divorce. So if you go through a separation, that does not automatically remove that spouse as a beneficiary of your investments or your life insurance. And same thing with a divorce. So you've got to carefully look at that and make sure you're making the appropriate changes. And if you have ongoing obligations, maybe after your divorce, if there's spousal support, or other things to consider, you've got to take a hard look at that and make sure your planning is taking all of those things into account as well. If you're feeling family pressure, again, consult a lawyer. Great idea. We will isolate you. So lawyers we're trained to work with our clients independently. So we have to remove any outside sources, other family members from the estate planning process, whether that's doing a power of attorney or a will or a healthcare directive. We need to isolate you, and then we want to have a conversation with you about what you really want. And if there are concerns about what a family member might do, or them putting pressure on you, or they want to see you walk out of that office with a certain document, there are things we can do to help you and protect you and make sure you end up with still documents in place that are what you want. So please, yes, talk to someone, or we do also have a senior support line that we're going to give you at the end of this session as well. People wishing to avoid problems relating to the distribution of their estates, definitely a good reason to consult a lawyer and make sure things will flow smoothly after death, or even again with powers of attorney or anything else. So making sure everything that needs to be taken into account is taken into account. And yes, last of all, everyone should consult a lawyer for their estate planning. Prior to meeting a lawyer, what can you do to prepare yourself? So if you can put together a family tree, get the full legal names of anyone that you're expecting to include as an executor under your will, as a beneficiary, anyone that you're incorporating for any other reason, guardianship, get all of those names in advance. The lawyer will want to get a feel for your family tree, so what your family looks like. You'll also want to come ready with an understanding of your assets. So the lawyer will want to know what you currently hold in investments, what properties you have, what are they worth, what's the intention for what happens with them on death. Do you own anything jointly with other family members, with your spouse? Is there anything that you've co-signed with kids? Are there any loans outstanding to you? Do you have any debts? Do you have any loans? Considering the exact directions that you want in the will. So we're going to have a discussion with you about that. We'll talk through who are the best executors for you, considering alternates and backups. Typically spouses are appointing each other first, but then they're looking to other family members if they're both gone. And typically it's a fair amount of work once a couple has both passed away, because that's now this joint estate, and there's usually a bit more to do in terms of like gaining control of property and selling things and distributing amongst a larger set of beneficiaries. So gathering information on beneficiaries. I mean, there's certain things that we're going to need to know, like, is there a disability in the family? Is there anyone that's a beneficiary that might be receiving government support? Is there anyone that's lost capacity within the family that might be a beneficiary? So all those things are going to be important to the estate plan.
Just on that topic of beneficiaries, there's a question here about, so what happens if someone that you've named a beneficiary to receive a gift in your will dies before you and you don't update your will? What happens to that gift?
Yeah, so generally, if you've got a will done up, if I was doing that will, I would have contemplated that. So I would have added a line that says, if this person passes away before me, I want this gift to pass on to their children, or I want this gift to fail because this gift, you know, the house is only meant for them. And if they're gone, then I don't want them to have it. So ideally, you can address that in the will itself. And if you haven't addressed it, then it depends on the relationship you have with that individual. I would say, like, let's say generally that gift is going to fail because the person predeceased you. But there are certain circumstances where that gift could still survive and go to their estate. So best to address it in the document itself. And just so last points on this slide are discussing that plan with your family. So to the extent you're at least comfortable discussing the plan with your family, it is, again, nice to have no surprises. It can really reduce conflict. And I think I kind of always say this from a parent perspective, but if kids hear a difficult information from you rather than from their sibling executor or after you're gone and emotions are high, it's generally better if that information comes directly from the parents. So even if they're hard conversations, it's probably better to have them now rather than just hoping for the best when you're gone. And if you're considering giving to a charity, there are all kinds of creative and interesting ways to give to charity, and some that can kind of add money back into your estate, or just give you some tax breaks, I guess would be a good way to look at it, and different forms of gifting. So a lawyer can walk you through that if you're kind of thinking about a charitable gifting option. Okay, when should someone review their will? I would recommend every, couple years, even every year. Again, you're trying to catch if there's been a change in your world, a change in your beneficiaries. If you did have, in that last example, a beneficiary pass away, then that might be a reason to update the will and address that gift and what's happening with it now. If you have a big change in your assets, so if you've sold a property and that needs to be addressed in the will, then you may want to do that. All kinds of different things, the marriage, the changes in relationship status, a move to a different province, a change in a beneficiary having a disability or joining, being on government support. Those kinds of things would be big changes that you want to review. A change in your descendants or a new child if you're now looking at incorporating children as beneficiaries, all that kind of stuff. So lots of reasons to look it over. Just pulling it out once every 3 years, giving it a read through, making sure there's nothing that you're saying, oh, wow, that's not working for us anymore. We've got to change that. So you can self-review that stuff, or you can also have a lawyer review the document with you and let you know if there's anything on the legal side that might have changed in the last few years as well. Okay, will dues. Okay. Do consult a lawyer. Do review your will on a regular basis. Do keep your will in a safe place, a safety deposit box, or in a vault at your lawyer's office. Safety deposit boxes, make sure everyone knows where the will is stored. I like to do a location document that I give to clients and they can give out to family members, so that if something happens and family has to track down the power of attorney, or you've passed away and they have to track down the will, they know where to go looking, and that original will is not lost. That original will is what you need if you have to go through that court process. So You always want to make sure it's in a safe location and a fireproof location. Fireproof lock boxes at home work too. Let your executor know they've been chosen and where to find your will. So we want them to be on board for acting. And do be aware that legislation may affect and impact your testamentary wishes. So that's really referring to different claims that people could have against your estate. So in that blended family situation I brought up earlier, if you were someone with a spouse, you're married, but you have kids from previous relationship, and you're thinking, I can leave all my estate to my kids. You know, my spouse, she's going to do that for her kids as well. Your spouse would still have claims against your estate under our Family Property Act. So it's kind of like if you were to go through a separation and you know how you have claims against each other and you go through a family property accounting to divide up your assets, that kind of concept applies on death as well. So a spouse who's left nothing under a will can go after the estate and make a claim for proper accounting so they get a portion of your estate. And they can also make claims as a dependent, and so can any other dependents you have. So if you're financially supporting someone else and they relied on you, they may also be able to make a claim for support against your estate as well, even if you've left a will that directs everything to go to other beneficiaries. So those are, again, important things to know about. That's part of why lawyers are asking you all these questions about your family tree and who's in your world and who you're supporting. Okay, these are the don'ts. Don'ts. Don't wait until it's too late to plan your future. Don't sit back and think everything will work itself out. Don't forget about tax implications, especially if you have substantial assets in your estate. So that was kind of one of those examples I gave earlier, is if you're not thinking about the tax that will hit the estate, because the estate is generally the one that's responsible for paying all your debts and expenses on death. You want to kind of think about that. And if you're directing assets outside of the estate, make sure the plan is going to work and everyone is going to be equal in the way that you expect. Don't rely on will kits or holograph wills, I'd throw in there, as a means to distribute your estate. They're just not going to take into account the complexities that will come into play for each person. These documents too, a will should generally evolve as you age. So when I do wills for young couples, I find we're often kind of at this stage where we're thinking about guardians and we're talking about what we're doing with education savings plans for kids and talking about how long we hold money for children and at what age we distribute it at. So that's kind of a big focus at that younger age. And then I also have parents come back to me when their kids have then hit adulthood. And at that point, they are looking to update their executors and maybe put kids in that role because their parents are older now or their siblings aren't as appropriate for that role. And then in that stage, they're removing all the guardianship trust provisions and maybe looking at gifts, even going to grandkids at that point. So it's an evolving document, and it's because your world is evolving. So we want to make sure it's reacting to any changes in your world. Okay, we're hitting the disability planning section here. So first thing we will talk about is Henson trusts. Okay. All right, so there's a few different strategies that can come into play when you have a beneficiary that has a disability. So generally what we're talking about here is a beneficiary that might be receiving government support. So right now our program in Manitoba is EIA disability, employment and income assistance disability category. So EIA has very specific rules about what a recipient can have in their own control. So there's a liquid asset limit of $4,000 for a beneficiary or a recipient of government support. And if you have funds set up in one of these other vehicles, we're going to go through here, then these are treated as exempt from EIA's view. So when EIA is looking at that recipient to see what assets they have available to them to fund their own support, they will treat Henson trusts, EIA disability trusts, and RDSPs as exempt. So they will not count them against that person. So if you have these vehicles set up, it will not stop this beneficiary from getting the inheritance if it's in one of these vehicles, and they can keep receiving their government support. So strategy 1 is Henson trusts. And I would say this is the best possible strategy you can use for a beneficiary that has a disability. A Henson trust is a structure where the inheritance you're leaving for your beneficiary is actually set up in a separate fund and managed by a trustee who's a separate person. So the trustee actually takes control of the inheritance, and they have specific terms that they manage that money by. So they're going to manage the funds, they're going to invest it, they're overseeing the money, and they're making decisions about how the money is used for that beneficiary with a disability. So the whole idea behind this trust is that the decision-making and the control is with the trustee. So the trustee has total power over the money. They decide if money is paid out or not. There's no ability for your disabled beneficiary to demand any money. The trustee has total control. So it's considered a discretionary trust, which would be, if you've heard just the term discretionary trust thrown around, it's the same thing in this context as a Henson trust. Henson trust is just the Ontario case that gave this trust strategy its name. So that's where Henson trust comes from. So on death, basically, you're setting aside this share for that beneficiary. So the same way you might be dividing up your estate equally between your children. So if you've got 2 kids and one has an intellectual disability and is receiving EIA support, you could have that half of your estate handed over to a trustee, and the money they manage and the payments they make can be treated as exempt from EIA. So if that child with disability needs something else in addition to what they're getting from the government, the trustee can pay for those extras out of the fund. And that fund can remain in place all the way until that beneficiary passes away, or until the money is used up on their care. The second strategy is an EIA disability trust. So EIA disability trusts are a strategy we have allowed under our EIA program. So it's something that's Manitoba specific. This exact strategy wouldn't be something you'd find in other provinces. Basically, what it allows a person who's a recipient of support to do is to set aside some money in a separate account, which will be treated as exempt. You can set aside up to $200,000 in this type of account, and the money can be drawn on as long as it's used for a disability-related expense. So it's a little more restrictive than something like a Henson trust. A Henson trust could be used for anything. The trustee could spend the money on trips, on video games, on whatever that person wants. For an EIA disability trust, it's supposed to be connected to your disability. So supports that you need. It could still be for housing, for modifying your home, other services you might need to have come in, clothing, like basic. So it's a little bit more restrictive, or I guess quite a bit more restrictive, depending how you look at it. And the person managing that money could either be the person with disability themselves, if they have the capacity to do that, or it could also be a trustee that's set up in that role to oversee that fund. To set up one of these accounts, you do have to provide certain information to EIA. So you should have a trust document that actually has an initiation date. So the date that trust was set up, when the money was set aside in the trust or in the account. There should be certain terms about how the money is used, kind of setting out these disability purposes within the trust terms. You also need an annual report to EIA about all the funds that were paid out of the disability trust, the EIA trust. And what else do you need on this? That's the things I can think of. I think I'm missing one thing, but there's a few just reporting requirements with EIA on this one, and you're a little bit more restricted in the funds and how they're used.
There's just a question here.
Yeah.
Sorry, there's just a question here around who can be the trustee of these trusts. And I think this came up during the EIA trust more particularly. And specifically, could the neurotypical child of the 2 children be the trustee of the trust?
Certainly, yeah. So that's commonly a strategy because that's maybe the person most in tune with the person with disabilities needs and support, and what are the extras that we want to be paying for them. So definitely having another child, if that's an option for you, managing those funds is a good way to go.
And just to clarify, I think we're talking adult children, not actual children.
Yes, sorry, I am thinking adult children too. You wouldn't be able to have a trustee who is under the age of 18. Thank you for clarifying that. Yeah, was there any other questions on either of those two?
Yeah, on the EIA Disability Trust too. Would something like massages for someone be eligible if that's related to their disability, or something like iPad or communication device if they're nonverbal? Like, are those the kinds of things that would be tied closely enough?
I would consider both of those things would be included. Yeah. Ultimately, so what you're supposed to do is go to the EIA worker and they're supposed to tell you if it will qualify or not. I don't know if every worker that's there is going to be super well versed in this stuff, but if you can get an opinion from that worker and give an explanation about why this is connected to the disability or why it's going to support this person, and you can get a written confirmation back, then you're good in that case. So I think in a way it is sometimes just pleading your case for what these expenses are and that they're going to qualify, and that way you're covered in case and like EIA somehow later comes back and says, is this really a disability related expense? I guess that's really what you're protecting yourself against. Is that all of them for right now? Okay. The other thing I was going to say about EIA trusts is, so generally that strategy is used when the person with disability themselves has come into money. So if they have less than $200,000 that somehow has come to them, and that's over their $4,000 asset liquid exemption, then they have to find a strategy to deal with it. So putting it into an EIA disability trust is one way to do it. One of the other complications that can come in then is who's setting up this trust and who has capacity to set up the trust. So the individual might have capacity to work with a lawyer and understand this concept and what we're putting into place here. But if they don't, then you've got to look to a different strategy for someone to set this up on their behalf. So then you're looking to, do they have a power of attorney in place from before? Do they have a committee in place or a substitute decision maker? They could set up this trust on their behalf. So there's some complexity to just getting this EIA trust in place as well. Whereas the Henson Trust, so a Henson Trust is something you can set up under a will. It's terms that you generally include under a will that deal with an inheritance, and it's pre-planning you do. An EIA trust is kind of more of a band-aid strategy later. So if someone didn't do a Henson Trust and an inheritance was left to someone receiving EIA disability, they could set that money aside as long as it's under $200,000 into an EIA disability trust. If you're over that $200,000 limit, then you're out of luck because you don't have that Henson Trust in place already. You can't put it in place later, and you're beyond the limit of what you can do with the EIA trust. So you've just got to spend down the money until you're back in a eligible position for EIA. Okay. The third vehicle that you can use potentially is a registered disability savings plan. So the first two ones we looked at, Henson Trust, you don't necessarily need to qualify under anything in order to set up a Henson Trust for a beneficiary. The second one we talked about with the EIA disability, if you're a person receiving EIA disability, then you're a person that could set up an EIA disability trust. You're a person that would benefit. For an RDSP, you have to be a person that qualifies for the disability tax credit. So in order to qualify for that tax credit, you basically have to be assessed by a physician that your disability affects your daily living. So there's a form that has to be filled out and submitted to CRA. You have to be approved. But once you get approved for that, that opens the door for opening an RDSP. And the RDSP is a great plan. It allows for certain matching. So there's government grants and bonds that can go into the plan. It can be set up actually by a parent. So the parent could even be the one making contributions, or a different family member can set it up and make contributions. So there's some flexibility in that way. And the idea really with it is it's meant to be a long-term saving vehicle. So it's meant to kind of be an RRSP, like a retirement savings plan kind of idea for the person with disability. So long-term, you're putting this money in, you're getting these grants and bonds. There's a point at which you're no longer able to contribute anymore. I believe it's age 49. And then you have to wait this 10-year waiting period, which could happen earlier. You could stop contributing earlier in the person's life, but you have to leave it in for 10 years before you start to withdraw on it. And once you start to withdraw, you can do it. There's a few different methods for how you withdraw, but basically it's like an income stream at that point. So it's paying out like a pension or an RSP or like a RIF if it converts into that. So that's kind of the idea with RDSP. So it's meant to support that person with disability later on. And there are some other flexibilities. If there's a reduced lifespan, they'll let you pull earlier in certain situations as well. The one thing RDS, oh yeah.
Go ahead if you're going to keep continuing.
I'll say one more thing on RDSPs. I mean, this is kind of in the context of the whole thing, a newer plan. So we haven't seen tons of people couldn't get to the point where they're actually drawing on it yet. But one thing to keep in mind too is any money that remains in that RDSP when the beneficiary passes away. So if you set aside money for your child with disability and you pass away, that RDSP stays there and eventually starts to pay out for that child. If that child then passes away, any money that's left in the RDSP then goes into their estate, actually. So that could be a reason why you might even want that child to have a will if they're capable of doing one, because that money will either have to be dealt with on an intestacy through a court application or dealt with under their will. So just another thing, like the RDSP falls into the person's estate, whereas the Henson Trust, you direct in your will what happens on the death of the beneficiary. So you get full control over what happens with that money later too.
Okay, we have a few questions here. So if the person with disabilities is status First Nations and has received compensation from the government, like for example, through a land claim, could they set up a separate trust or bank account to ensure that money stays exempt for EIA purposes?
Those types of like settlement amounts should be exempt themselves, actually. So the EIA Act has a list of other like little exemptions that I don't come up very often, but those ones always fall. And there's always land claim settlements, and I would bet that those fall within other exempted categories. Yeah, if you want to get that, if they had a specific thing, they could shoot me an email or something, because I think I could find that section for them. It's pretty deep in that regulation, so I think it's a bit of a hard thing for you to find as a non-lawyer, but my understanding is it's probably exempt separately. And you could also confirm that with the EIA worker, like they should be able to confirm that for you too.
Right.
Yeah.
Just an example, if someone receives $300,000 as an inheritance, could they choose to put, $200,000 in the EIA trust and spend the rest, or is everything then tainted or offside and can never be an EIA trust?
Yeah, so one thing I didn't mention, which is right here on the bottom of this slide, is the $200,000 limit. It's a combined limit for what you put in the EIA trust and the RDSP. So you could put $100,000 in each or $200,000 in one, but you can't go beyond that contribution amount. Those funds could also grow beyond the 200,000 as long as all that you contributed was 200. So that's an important point too. And then, sorry, your question was, can you repeat it again?
Can they choose out of an inheritance right, the portion that goes into the trust and then have flexibility with the rest, or is that not possible? Would that taint it and never have any portion of the money in an EIA trust?
So for a $300,000 inheritance, I would direct all of that into a Henson Trust because it gives you the most flexibility. And the terms, so when I do a Henson Trust, there's all kinds of terms about how the money's spent, and it's basically giving directions to that trustee about how they're managing the money long term. And one of the things I include, if it's a person that does have an RDSP or is expected that they might be able to open an RDSP in the future, there's an authorization for the trustee to add money into that RDSP. So my best planning advice in that situation would be put the full $300,000 into a Henson Trust. That trustee manages it. They could slowly add money into the RDSP and take advantage of the matching that the government does. So that's actually, instead of just dumping 100,000 in there right in 1 year, which would only give you 1 year's worth of matching, so you can actually maximize what you're putting in there. I would use that strategy, and I would leave the EIA disability trust completely alone because it doesn't get you anywhere further. So it's more restrictive in how you spend the money. Remember, you have to use it on disability related expenses. If you have it within a Henson Trust, it's more flexible. You can use it on anything. So why bind yourself into a more restrictive mechanism than you need to do? So that's my advice in that case scenario.
A question here about the RDSP and in terms of who withdraws the money or pulls the money out of the RDSP if both parents are gone.
Yeah, so RDSP money is really something the beneficiary is entitled to. So this can be kind of complicated and sticky too, because if you have a beneficiary that doesn't have a decision maker appointed for them, then they're the person, and if they have capacity to manage the money, then they're the person entitled to the money and to manage it and to get the payments and to direct how it's being paid out to them by the financial institution. If you do have a decision maker in place, so that could be an attorney under a power of attorney put into place in advance. It could be a substitute decision maker, or it could be a committee. So any of those roles could act on behalf of that beneficiary and manage the money, and you're in kind of a better position if that's the case. One of the questions that does come up, if you've got a person with disability that's like competent, mentally competent to manage the money, but maybe poor decision making with the money, that maybe an RDSP might not work if there's no other mechanism to oversee what they're doing there. So that can be kind of one of the downsides, is the control element.
A question here about Henson trusts, and where do you go to open such a trust? A regular bank or a specialized financial advisor or an estate lawyer?
Yeah, so it's kind of a combination, I guess. So to set up the trust itself, generally we're talking about doing that on death. So it's something we're talking about doing in a will. It's not something you would set up today, just getting it ready and setting aside money at the bank. Typically, you want to keep control over your funds during your lifetime, not tie them up in a trust now. It's just something you want to have set up on death when you're now moving that money on towards your beneficiaries. So step one is meeting with an estate planning lawyer who's well-versed in Henson Trust planning, so someone who knows what they're doing in that area, and putting together a plan for a Henson Trust, talking through who those trustees are, talking through what the long-term plan is with your beneficiaries. So I want to know, like, where do we think that person's going to be living, who's going to be involved in their world, the trustees that are going to be in place, are we compensating those trustees, all these different questions that can come into play. If there's an RDSP or not, is there a committee, is there an SDM, all that stuff. So step one is figuring all that out and putting together the plan for the Henson Trust. When you then pass away, whenever that day comes, your executor should have your will or know where to go find it. Your trustee should be aware that they're appointed in your will, and the executor and trustee to a certain extent are going to work together to get that trust in place. So the executor is going to be responsible for dealing with your whole estate. So actually we're heading into that section right away. So they'll have all their duties in administering your estate. And then they're going to hand money over to your trustee that's managing the money for the Henson Trust. That trustee then takes that check and they can actually go to any bank, and it's setting up a bank account. And they're going to manage the money as a trust from that financial institution. You might have something else too. So you could have other property going into that Henson Trust, like a house or something else you're leaving that's meant to be part of that trust for that beneficiary. So I hope that answered the question of kind of the steps of how it plays out.
So, and there's a bit of a follow-up question here of, can you hold a residence in a Henson Trust? For example, if the disabled child lives in the home with the parents and the parents want the house to be kept and allow the child to live there when they are gone so that they don't have to go into a facility?
Yeah. So I think you've just got to look at your estate plan and is that practical? So if that house is going to be left as part of that child's share, is there enough money there to fund taxes every year and fund the other expenses of the home every year? And if that individual's living at the home on their own, are they going to need supports coming in? Do we already have those supports, or is that another cost that we're going to have to add into? So definitely, that's definitely an option. And if there is a plan in place or an intention to leave a property for someone who's receiving EIA, the best way to do it is to put it into that Henson Trust. Technically, an EIA recipient can own a property if they live at the property, but the issue that happens is if they ever have to sell that property, like if they're moving to a different location or they're now moving into a rental situation or something else, the cash from that sale, the money that now comes into their hands, is now beyond their limits to put it into any of these accounts, and it's not exempt because only the house is exempt under our EIA rules. So it's a weird situation that's not really well planned for under our EIA program. So best planning is put that house into the Henson Trust. And there's even an amendment for tax purposes, like you can access a principal residence exemption, which means you don't have to pay capital gains on the house for the period it's held in that trust for that beneficiary too. So that's a nice tax benefit of the Henson Trust generally that qualifies as well.
I'm going to try to get all these questions in. I know we only have about close to 10 minutes left, and we have one more section of our presentation to go to, but these are really good questions. So is there a concern about that sort of that time period between when the will comes into effect and this trust is, the Henson Trust is getting set up, about accessing money during that time between when someone passes away and when everything might be kind of up and ready to go?
Yeah, great question. So it can take a few months just to even have an executor gain control of accounts. So that is a question I do like to look at too. Is there a need for support in those interim months before a trustee's gotten control over the funds or a portion of the funds, and maybe even before an executor's got control, that they can make an interim distribution to help support that beneficiary? So in a case where you're very concerned about that first 6 months, we want to make sure there's something there to support the beneficiary. You could, in that case, look at something like a joint account or a life insurance policy, or something that's paying out and is well documented to still be part of your estate or still be part of that trust. But to get the liquidity piece where the cash is available right away, you do have to do a little bit of special planning and make sure there's some fund there that's, again, well documented. If it's a joint account, what the intention is for that account, and that everyone's aware of it too, because that will help you get over the hump of dealing with a financial institution. So like generally, if you pass away, all of your money's in your name alone, financial institutions will not generally release the funds without probate, depending on how much is there and the circumstances. So you might be waiting for that probate order for 3 months or a couple months by the time the executor gets the documentation together and we get that court order back. Can be longer depending on how complicated the work is that they're having to do. So at least when the executor gains control of funds, they can make an interim distribution if the money is really needed by that trustee. And then the trustee at least has a little bit to work with to support the beneficiary. But probably what you're looking at is like an interim situation. And then generally estates take a while to wind up. So the final payment to that trustee for their share may not come till much later. But that's how we deal with it at the various stages at the beginning.
There's just one other question, a general comment around whether you've heard anything about the proposed changes to the EIA program and whether that's going to have any impact on these exemptions that we've been talking about.
Yeah, very interesting times here. So we have a new support act coming into effect. It's called the Disability Support Act, and it's intended to support people with severe and prolonged disabilities. So the idea is it's going to take a big chunk of people out of EIA disability and put them into this new program. The new program is, meant to be throwing you through a few less hoops, so there shouldn't be the same obligation to prove your disability over and over every year, things like that. So it's a new program they're putting into place. The act that brings it into effect has been passed, but it's not coming into effect for another at least year or more. The actual content of what the program is going to look like will come with the regulations. So the act gets passed first, and then they develop all the regulations, which, to give you an example, with our EIA Act, the regulations I think are like 60 or 80 pages. It's something really, really long. And that's where all these rules about the RDSPs and EIA trusts and settlement amounts that are exempt and all these different particular rules all show up in that regulation. And the act itself might be, I'm not sure, 12 pages or something, much, much shorter. So the real content of the program is in development right now, and we don't know exactly what it's going to look like. I've been involved in the consultations about the development of that program, and I've certainly made it known the importance of having these strategies continue forward in the new program. I don't think eliminating them or having them negatively impacted in any way is going to be supporting this community. So those voices are out there trying to make sure these strategies remain in place, but it is open until we know what this program looks like when we see these regulations. Specifically, like the RDSP, I'm sure would be carried forward. That's a Canadian program, so I would expect that will continue to be exempt. The EIA Disability Trust is a creature purely out of our Employment and Income Assistance Act, so I would expect they would create a similar strategy under the Disability Support Act. Don't know for sure. And Henson Trusts themselves aren't actually treated as an exemption under the EIA Act, but Henson Trusts, through our case law across the country, are treated as something that's not a personal asset to someone receiving government support. So they're exempt for this other reason, kind of this overarching case law reason. And to try and keep it simple, we have case law from our Supreme Court that says basically each province is open to make their own rules about whether these types of trusts are treated as a personal asset or not. So it's always open to our province to decide to treat them as an asset. I would be absolutely shocked if they did something like that, because it would be against the trend of the rest of the country, which has been moving to treat Henson Trust as exempt. So we don't know what's coming, but hopefully it's not bad news and it's a better program for people with disabilities. But certainly I will be keeping my ear to the ground on this.
Thanks for that. We do have one last little section to run through really quickly, and we'll try to get there before 9.
Yes.
5 minutes.
Okay, state administration. So personal representatives are the individuals that are acting either as executors or administrators. We talked about executors appointed under a will, administrators when you die intestate and someone has to apply to court. Probate is not always necessary. That's that court application with a will. It will just depend on what assets you have at the time of your death. So if you don't have any real estate, if your accounts are relatively small, you may be able to access all of the estate funds with just the will and not needing a court order of probate. Personal representative duties, there's many roles that an executor or an administrator takes on. At the very beginning, they deal with funeral arrangements and paying those expenses. They're going to deal with collecting your assets and paying debts. They have to deal with filing your final tax return and filing estate tax returns. If there are any notices that need to be sent out for the estate, so if you are leaving a surviving spouse behind and you're not leaving your entire estate to them, a notice has to be sent to that spouse. If there's other dependents, they may need to be notified. If there's any ongoing legal issues with you or for your estate, your executor is now inheriting those issues and working through them on your behalf. And the executor or administrator is also responsible for handling the accounts for the estate. So they have to oversee the finances, the money that's going in and out to pay people. They ultimately have to report to your beneficiaries. And if they're looking for compensation, they've got to get agreement from beneficiaries regarding that. And they're the ones working with the lawyer, with the administration, putting together probate documents or that court application, and ultimately distributing the property, which will be either in accordance with the Intestate Succession Act, if you died without a will, or in accordance with the will and whatever terms you've left behind for them. Administration dues. So do evaluate the potential downside of acting as a personal representative before agreeing to act. It is a big, big role that you take on. There is liability to it too. Once you step in, you've got to continue on in the role, and you need to be acting as a diligent individual in that role, managing funds and managing property, and beneficiaries you are accountable to beneficiaries as well. You should definitely obtain legal advice before deciding to act, and throughout acting. You want to make sure that you're in touch with all the obligations and the steps you should be taking, and the law on whether you're doing an estate by administration or with a will. Do hire a lawyer to assist with the procedures and the legislation concerning the estate issues. There could be complexities that arise over the course of the administration, so you want to make sure you're getting that advice and keeping accurate records all the way through the administration, because you will have to report to those beneficiaries. Don't agree to become an administrator if you do not have patience or the abilities to carry out a very long-term project, because it will be at a minimum a year to 2 years as an average simple estate, just based on the tax filings that you do have to do. Don't agree to be appointed personal representative if you're unable to reach agreements or resolve matters with those other people that you're acting with as an executor, or with those beneficiaries. So if you're not going to be able to get along with those beneficiaries, maybe that is not the role for you. Don't take those duties lightly. Closing comments. So estate planning documents should be prepared by a lawyer. You should get advice when you're going through that process, and you should get advice if you're handling the administration of an estate. Estate planning for your future should not wait until later in life. You want to be getting to it now so that it's dealt with right away. And we want to make sure that your wishes are followed by setting up documents just for you. These are our extra resources for you. I think I did that with a couple minutes left.
Really, yeah, we've got 2 minutes left. And on the estate administration piece, that the link that's up there for the public guardian and trustee, they have a really, really thorough guide for anyone if you are administering an estate, if you've been named an executor or have been appointed an administrator, called the Deceased Estate Handbook. I think they need a catchier title, but it's very comprehensive. So we just Krista just blew through a couple slides on those points. So if you want more information, that's a great resource on that topic in particular. And the lawyer referral line is there too. We did have, just to circle back really quickly in our last minute, I missed a bit of a clarification on the point around someone who's receiving a different type of government support, like a land claim settlement. It is exempt for EIA purposes, but so EIA has said it is exempt, but you cannot mix it up with other money. And so in order to make sure that it remains exempt, is it enough to put that into a separate bank account, or do you actually need to put it into a trust? How would you make sure that it stays exempt?
You should be able to just put it in a separate bank account. I think if you have really clear documentation about what you've done there, and I mean, a trust would only be a step you're taking if you're going to be formally putting the management in place with someone as a trustee long term, which comes with other obligations. So if that's really what you're looking to do, you could do it that way. But if I think just the key is making sure if EIA comes back and asks questions about that money, that you can show the contribution that was here was this money from this settlement. There was never a later contribution from another source. That's the key, that money was always treated separate. So as long as you're doing that and you can show that, I think you're going to be in the clear.
Just a point of clarification about, you mentioned a new program other than EIA. How will we know which to apply for when age 18?
Yeah, kind of watch the news and see, Google this here and there every few months. I don't know, because we don't know who actually fits the category of severe and prolonged yet. That's going to come out in these regulations. So great question, and none of us know. So I'm assuming we'll see more publication about all of this. It's something I intend to blog about more, like we do some like posts on our website at Tradition Law. So I'm hoping to write more about it when we know more, but yeah, we just don't know yet.
That's all of our questions, and we're at 9:01, so on my clock anyway.
Yeah,
so I think we've just hit the end of our program today. Last chance for any last questions right now. I think a number of people have logged off already.
Okay.
So thank you very much, Krista, for your time and your expertise tonight. And thank you everyone for joining us. We hope you found this helpful and informative.